Um, let me just talk you through what I mean when I say, can they do that at work? Is that legal? When you're an employee in the UK, England, Scotland, and Wales specifically, and in Northern Ireland, you have a number of rights that come from a number of different areas of the law. And what I have found, because my background is not actually in the law, my background is in technology. But what I found is that we just don't know. We don't know what our rights are. And as a result of that, I think employers are able to not really have to focus too much on making sure that they're actually ticking all of the boxes like a lot of the time, unfortunately. And so the kinds of things that I see often is people don't realize that discrimination is happening because they think that discrimination is something really simple, like, the really classic discrimination. Oh, I found out that I was pregnant and therefore my boss said that they wouldn't promote me. That, I think everybody kind of knows that that's discrimination, but there are actually 6 types of discrimination. And I don't think a lot of people know all the different things that actually are really unlawful here in the UK, even within just a tiny little bucket of discrimination. I've got a person here saying, I requested my personal file before my hearings from my employer. They said it's holidays and they can't do it. Well, that's ridiculous. Well, you're more than welcome to ask the court. So if you need files before an employment tribunal hearing and they're not giving it to you, I would email the tribunal about that. They can't just say no. Or you could put in an application to postpone and say, I need to postpone until after they give me these files that I requested, and see if that lights a fire underneath them. Hi, Stevie. Good to see you. So what I'm typically finding is that people just don't really know about what their rights are and what they can do, and even how to do the process if something goes wrong at work. So that's what I'm here to answer questions about. Let's see, I've got a few other questions here. I got my tribunal date at the end of August. Do I have to send a schedule of loss to the respondent? Connor's asking that. Great question, Connor. So the date at the end of August, you should get case management orders next. So I'm assuming you had a preliminary hearing, and most people do. Sometimes you don't if it's a more straightforward case like unpaid wages. But normally you have a preliminary hearing and then they set a date for the final hearing, and then you'll get a series of letters or a series of dates from the tribunal called case management orders. And that will set out the date of when you need to prepare the schedule of loss, which is definitely something that you'll need to do next. When you're going to exchange evidence with the other side, and if witness statements are written down, which they are in England and Wales, then you'll put that in there as well. And then the final prep before the final hearing. I've been offered, let me just look, £15,000 to settle. I feel like the judge from Employment Tribunal is pushing me to. Well, that's super interesting. Did you have a schedule of loss, and what were you looking for making visible? So £15,000 really depends on the case and the situation, and I can go into a little bit about how claims are priced, if that's helpful. Stevie has an appeal hearing next week, looking to get someone reinstated on unfair dismissal. Oh, well done. So for people who don't know, Stevie and we've been doing lives for a long time. Stevie works and supports on a union. And so Stevie's a real one. Like, well done, Stevie. And we are actually now working with unions properly. I don't know which one you're in, but if you want to drop us a DM, I'd love to hear about how we could help your branch, because we're starting to try and help reps support their members. Okay, let's see who else. Okay, so it's a menopause discrimination and a failure to make reasonable adjustments. I wasn't able to go back to my role because of discrimination and treatment. So let's talk a little bit about how you price an employment tribunal claim. How do you know what it's worth, right? So the core thing, let's say it's like an unfair dismissal case. Unfair dismissal is really straightforward to price because it's all kind of just a formula. It takes things like your age, how long you work there, your salary, and it basically kind of gives you, I think it's called, I can't remember the name of it, but there's like a standard award for that sort of thing. And the other predictable award is about losses. And there's two types of losses. There's past losses, which is a good example would be I was unable to work for 2 months after I was sacked, and so that is a loss of 2 months worth of wages. Or I was unable to work for 2 months after I was sacked, and then I had to take a part-time job at a shop, which meant that I was earning half of what I usually earned. And it took me another 2 months there before I got another job at roughly the same amount. That would also be a past loss of the full salary for the 2 months plus the 2 months on the half salary. Future losses is about, well, actually, it's going to take me another 6 months, year, whatever it is, to get back up to the same wage and level that I had before all of this happened to me. And so that's called a future loss. And that's where you can really start to paint the picture of, if it's almost like I describe it as, in Marvel movies where they have like the timelines branching. So imagine that the bad thing hadn't happened. What would your salary have been on that path if the bad thing hadn't happened? And then the timeline branched and you have this path, and that's what did happen, and that's what you did earn. And the difference between those two branches is your past and future losses, if that makes sense. So yeah, there's another thing called injury to feelings, which is a very important part of potential pricing of cases that to do with discrimination, I think whistleblowing as well, but discrimination in particular. And that is literally there to compensate you for the injury that you felt, the injury in your feelings that you felt. So, the words often we see are humiliation, upset, distress, things like that. And we have a whole webinar on injury to feelings, like how to price an injury to feelings claim or a compensation request that is inside the Vala platform. So if you go to vala.uk and you create a free account, and then you go to our webinars page, in there you will see lots of different webinars that explain lots of different things. And one of them is about injury to feelings. Okay, so let's see if we can answer a few more questions. I'm going to switch quickly over to YouTube. Hi, YouTubers, and answer a question here. How do you prepare to structure cross-examination questions? Do you have any templates to help draw out the legal tests on issues such as discrimination arising from a disability or failure to respond to a statutory working request? And so general, lots of questions. How do I avoid getting trapped? So CK, thank you for that question. I completely understand where you are. And in fact, we have another webinar. When I talk about these webinars, these are paid webinars, but they cost about £17. So hopefully affordable. So we have another webinar called How to Prepare for Cross-Examination. And it was a fascinating webinar for me. It was co-hosted with one of our legal coaches, Samira, who has tons of experience in the tribunal as a lawyer. And she really goes through how to be cross-examined and how to cross-examine. And so, CK, to answer your question about the legal tests, I would look at your list of issues, because those are the legal tests that are going to be considered at the final hearing, after the final hearing, at that final, during cross-examination. So I would rely on your list of issues for those legal tests. And if you go to the Vala website, create a free account, and then go and look on that webinars tab inside the platform, you will see that cross-examination webinar. And we do a tiny bit of role playing in there, lots of stuff there. And if you do want some practice or help, you can buy coaching with Samira or any of our other coaches. They're all fantastic. And you can find the link for coaching inside the platform as well if you just create a free account. And just so people know, the free account isn't like a trial. It's free forever. The free parts is to track your case. So keep track of everything that happened. And if you've ever been on a live with me before, you'll know that I bang on about this all the time. It's called contemporaneous notes. Most people don't know that if you just write down what happens to the, if you just write down what happened, roughly when it happened. So weird meeting with boss, who, what, where, when, all that kind of information. If you just write it down, that's evidence. Because people often say, oh, well, it was my word against his. Your word matters, especially if you had notes, any kind of just like a text message to a friend, all of that. It's called contemporaneous because it was in the moment. You wrote it down fresh. And so that's much more credible than, if you wrote it down like a year later, for example. So that's why we built that as the first feature of that timeline, and that's completely free. So yeah, that's a little bit about the platform itself. And so all these products that I'm recommending, you'll find them all inside the platform. Okay, so let's look at, do you have a checklist of what I need to do for the tribunal? Not sure how to put it together. Great question, Kat. So it depends on what stage you mean. So do you mean at the very beginning of tribunal? Like I haven't even submitted an ET1 yet. We have a fantastic little kind of like map of how the whole process works. I don't know what the link is, so it might be on our link tree. Let me just quickly see if it's on there. The Employment Tribunal map. Okay, I'm logging in. Sorry, I'm having to go around my phone to log in. Give me just a second. Yes, so we do have a map that shows the whole process and kind of how it all hangs together. And let me see if it's in here. No, it's not on the link tree. So I would email hello@vala.uk and ask them for that map. They're lovely. They will look after you. And then the other thing is a checklist for different stages. So let's say you've got, say you've put in the ET1 and you're looking to do your preliminary hearing. We have packages for each of those stages. And so if you go into the Vala platform and then you look in the coaching section, you'll see we, for example, have a specific preliminary hearing preparation package. And that's where the coach will go through what is going to happen at this preliminary hearing and help you get ready for that and practice and understand how it's going to work. I hope that answers your question. Let's see. Oh, goodness, I'm scrolling back up. Okay, cool. Oh, actually, I got it right with the, yeah, good. So you've put in your ET1. Yes, we can absolutely help you prepare for that preliminary hearing. And definitely good. If you just log into the platform for free, you'll see it in the coaching section. My former employer just updated their training policy in regards to a health and safety issue. I'm just checking to see if there was some context before that. That sounds like a good thing. Is that a good thing or am I missing something? Can I add an additional respondent even though they weren't explicitly stated during early conciliation? You can certainly ask to, Mid. That is a pretty common, normally I would see that happening at the preliminary hearing stage where you add in a respondent. All that stuff tends to kind of shake out at that preliminary hearing stage. So yeah, you can definitely make the request to do it. What I would do is put it in the case management agenda. There's going to be like is there anything else kind of box, or even a box about the respondents, and you can request to do it there, and then the judge will decide if they want to add them as a respondent. Okay, so we're talking about the offer of £15,000. However, I do feel that I feel like it's worth more than that. However, I am representing myself. I would say it's hard to know. I mean, I know a little bit about your circumstances, but it's hard to know without I can't properly assess your case here. But what I can do is we can assess your case and give you a rough idea of price for £149. So that's what we do. So we have a product called Merits Assessment. If you go to the Vala website, vala.uk, it is the hero product right there on the homepage. And what we do there, and this is for anyone who is in any stage, I would say, where they've maybe they've already put in their ET1, but definitely everyone who has not yet made a tribunal claim, and you're just like, is this worth it? And how much should it settle for? Should I take it forward? I have an offer. Is it fair? Our merits assessment product, what we do is we ask you for any documents that you have. We then put you in a 1-hour call with one of our legal coaches who then has like a summarized version of everything in front of them. They prep before they come onto the call with you. They get a good idea of what the situation is. And then they work with you in that call to understand, okay, what happened? They get specific with all the questions, and then they give you a report afterwards. And what we say is, okay, so you talked about this claim. So this will be somebody who thinks, oh, maybe I was like, was that discrimination? What was it? Then we'll say, well, we talked about these 3 claims, for example, and the report will say, this one we do not think has likelihood to succeed for this reason. This one we do think has likelihood to succeed for this reason. And this other one we also think has likelihood to succeed for this reason. And then we give you a price at the end. So if you want some kind of peace of mind about, should I just go with this or should I not, I would suggest perhaps going with something like that. It's more money, but it is at least a fixed cost at £149. Football fan is saying, I'd like to speak to someone on Teams or on the phone about getting some assistance with completing an ET1. Absolutely, football fan. I would highly recommend in that case, either. So I would say go to the Vala platform, and I would recommend a 1-hour coaching package. Or actually, if you're doing an ET1, if you are absolutely solid that you've got your claims right, do a 1-hour coaching package, which is £90. Or I would get a merits assessment, because the key parts of the merits assessment, the claims, that is exactly what's supposed to go into the ET1. When you see the report afterwards, knowing exactly the claims to lay out, that is best practice for laying out that merits assessment or the ET1 particulars of claim. And so I would go with either one of those suggestions. We do have an ET1 template as well, and it does have a review. It's just not a call review. So I would recommend, if you want to speak to someone, one of those two options. Okay, I will need to go. I can't believe this has flown. No, wait, hold on. Let me see. No, I'm fine. I'm fine for another 20 minutes. Good, excellent, because there's so many questions. Okay, so right, let's keep going. Oh, I'm so excited. I was worried that I'd have to go. Hold on, I would need to let me see if I can get these questions. Oh, here we go. That's much better for reading the questions. All right, so let's see. Let me see. I'm scrolling up. There's so many fantastic questions. Oh, it's so lovely to be back with all of you. Is there a cap on how long you can claim compensation? So if your case keeps getting pushed back. This is such a good question, Ellie. Yes, there is a delay, or there is a time limit, and it is a very difficult time limit. There are ways around it, but it is important. So the way that this works is you need to file ACAS early conciliation, it's called, which is really just filling in a form on the ACAS website, within 3 months minus 1 day after the bad thing happened. So let's say the bad thing happened on January the 1st, 2025. So that would mean 3 months minus 1 day, which is roughly sometime in March, you need to file ACAS early conciliation in order to preserve the ability to take it to tribunal later if you decide to. ACAS early conciliation is not it's just a form. You don't have you don't have to get everything right there, but you do need to file it. And what happens is that basically kind of pauses the clock. And then you in ACAS contacts your employer and says, do you want to talk to this person? Do you want to try and resolve it here? Sometimes they do, sometimes they don't. You don't have to actually engage with the process either. And then if ACAS early conciliation doesn't work, or if either party decided not to engage, then you will get what's called an ACAS certificate number. And then once you get that certificate number, the clock starts again, and you'll have usually a month after that, I would say a month to be safe, to put in your tribunal claim form, which is called the ET1. Now, the ET1, again, is a fairly straightforward form, except there's one part in particular that really catches people out, and that is section 8.2. And it's like a big text box, and it just says basically tell us what happened. But they don't really want that. They really don't want that. They don't tell you, but what they really want is for you to write what is called a particulars of claim. And what we do, if you go to the Vala website and look under how we help, there is a section for ET1. We have a template that can help you write that ET1. So that's how the process works. Okay, right. Let's see, I'm just scrolling down. My employer obstructed me by requesting a 2-month extension on my SAR 2 days before my appeal. Okay, well, first of all, I'm so sorry to hear that. I have seen a lot of situations like that where dirty tactics are used, delay tactics in particular. And generally they're there to wear you down, intimidate you, delay you. And often they work. this is a grueling process if you're in the process and if the employer is really committed to doing something like that. It's why we have our employment tribunal support group, which is a big monthly webinar that we hold where you can all get together and talk to each other and us about kind of what's going on, because this is a tough process. So the other thing that you can do is too much expansion on my, so subject access requests actually have nothing to do legally with the employment tribunal. So the employment tribunal, the subject access requests are part of the GDPR. It's a completely different area of legislation. It's very handy to do a subject access request because it helps you collect data, but you have a more powerful tool available to you to collect evidence if you're in the tribunal process, and that's called disclosure. So when you move past the preliminary hearing, those case management orders that I was talking about before, one of them is called the disclosure process, where you disclose evidence to each other. And both sides have to tell the other side about all the evidence that they have, even if it's not good for their case. And if the employer doesn't disclose something that you need to prove your case, and you know that they've got or think that they've got, you can file what's called an application for specific disclosure, which is basically saying to the judge, they say that they don't have this and they're delaying, but I need this for my case. And so I would like you to force them to give it to me, to order them to give it to me. That's called an application for specific disclosure. That's one of the templates that we have on the platform. Again, if you create a free account and you go to the templates section, I think documents or templates, can't remember which one, you'll see the template for that. Okay, so someone on YouTube, can you clarify anything around personal injury that could have been included in the remedy? I'm about to have a remedy hearing and I'm not fully clear on personal injury versus injury to feelings. Yeah, great question. So personal injury, to my knowledge, isn't typically something that comes into as a tribunal claim. Psychological injury sometimes does. And personal injury is literal physical injury. And I don't believe that is litigated inside the employment tribunal. I believe that's litigated inside a civil court. So that would be a separate area. Injury to feelings is about words like distress, humiliation. We see it often awarded when people suffered from depression. They had to get medication. They were unable to enjoy their daily life. They were unable to work again for a certain amount of time. Their partner saw a massive difference in them. They couldn't sleep at night, that kind of stuff. Then there's psychiatric injury, which sometimes, less frequently, is awarded on top. What we typically see there is, I think it's called psychiatric injury. I will check. But typically we see if the employer were acting in such a high-handed way that they literally did not care if you live or died, and they were just showing, like, almost scornfully treating you really badly, then sometimes the tribunal will consider an additional compensation for injury on top of injury to feelings, or in addition to an injury to feelings. But typically injury to feelings is the most common injury award type in the tribunal. Okay, quick question about what if I secretly recorded a conversation, and if I can use it, when do I disclose that I have this evidence? So we see recorded conversations used all the time in the tribunal as a short version, typically as a transcript. If you need to rely on it for your ET1, for example, if you need to say, I know and that they said this thing, or I'm trying to think of a good example. So for example, victimization. Victimization happens when you make what's called a protected act. So you speak up about potential discrimination at work, you suffer a detriment as a result of that, and you can link the two. You can say this detriment happened because of that protected act. So if, for example, in a secretly recorded conversation, your manager said, well, because you raised this issue, we think you're a real troublemaker, and so we can't put you in front of clients anymore, for example, then you probably list that on your ET1, and in which case they would know that you have that, and then you would need to disclose it as part of the disclosure process, which will happen at post preliminary hearing. But generally, the answer to any question of when do I need to disclose is at disclosure and not before. And in the general, in the general way. Okay, let's just see a few more on TikTok and then I'll come back to YouTube. Let's just see. Right. So grievance meetings. There's a few questions about a grievance meeting. So grievances, the first thing that's really helpful to know if you have raised a grievance is that your employer must schedule a grievance meeting because they must investigate the grievance. And so don't be scared, because I have been in the past, that they're asking you to come to a meeting. The first thing is they have to allow you to bring some types of people and should allow you to bring other types of people. They have to allow you to bring a union rep if you have one of those, or a coworker. They can't say no to those two. Also, if you have a disability of some kind, then they need to, like, they would really be in hot water if you had some kind of accommodation you were requesting and they said no to that. It's best practice for them to allow you to bring other people outside of those categories with you, but they can't say no to a union rep or a coworker. The meeting itself should be a fact-finding mission. It should just be very much about, I understand based on this information that you gave to us in the grievance that this is the situation. Please, can you give me more details about these things? It shouldn't be a defended, like a super defensive situation. They should be genuinely investigating in order to properly follow the grievance process. I don't know, Dee, what made the questions inappropriate, but yeah, I would, like, this is why I bang on so much about contemporaneous notes. I would recommend that you have a colleague or someone come with you to take notes, so that you have a record of what was said and what was asked. Especially because if, let's say you go to tribunal about something and you won, but the employer did not follow the ACAS code of practice when it came to a proper grievance procedure, then you could ask the tribunal to increase the amount that you won by up to 25%, depending on how severely they didn't follow that ACAS code of practice. Okay, so what that grievance meeting should be like, it shouldn't be like, it might feel uncomfortable because they might be digging into like specific facts, like specific dates, the who, what, where, the when. And if you can come prepared for that kind of stuff, that would really put you in a good stead for that meeting. But it shouldn't feel like you're the bad guy, if that makes sense. Okay, so someone said oh, good D, I'm so sorry. I was intimidated and I started stuttering. I did a grievance meeting once where I didn't really know how to do them and I just burst into tears in the grievance meeting. It's totally okay to ask for a break, and it's okay to actually say, is it okay if I write this down? And can you give me your questions and I'll answer some of them by email because I can't finish? Like, that's okay too. I mean, they are very scary and sometimes that's by design. My employer has said that I didn't appeal their decision. I raised a grievance. So if you raise a grievance and they say, okay, we've looked into this and we don't think anything has happened, you have the right to raise an appeal, and you should, absolutely. They don't often tell you that you can do that, but it is part of your right within the ACAS code of practice. If you don't raise an appeal, and let's say you go straight from there to the employment tribunal and you file a case, the other side will jump on that and say, oh, you didn't follow the ACAS code of practice. But equally, if you come back and say, well, I didn't even know that I could, and you didn't tell me, then I mean, that will be arguing about the award, rather like that 25%. It can go both ways. So if you don't follow the ACAS code of practice, they can ask to reduce the award by up to 25%. But if they don't, you can ask the judge to increase it by up to 25%. So that wouldn't really be about winning your case. That would be about how much you're getting as the award. Okay. My employer was not impartial. They were defensive when I raised my grievance. This is something that I really want to stress to everyone. They are not going to be impartial during the grievance process. The grievance process is not going to be impartial. Like, it's absolutely insane to ask your employer to be the person that you're complaining about and take the complaint in an impartial way. Some employers will do it really well. Some employers will bring in third parties to evaluate. Some employers, they really do try to remain impartial. But generally, you need to show the tribunal that you did engage with the process and you genuinely did try to resolve it. But in your emotions, do not have high expectations for that process. Just make sure you get it done in the time, and do not let a grievance outcome stop you from filing ACAS early conciliation so that you don't miss that 3-month minus 1 day deadline. That's the other thing that I just want all of you, I'm looking into 2 cameras here, look into my eyes. Do not wait for the outcome of a grievance or disciplinary if it is hitting up against that 3-month minus 1 day deadline. Even if the grievance has not been resolved, if they have delayed and you are hitting up against that 3-month minus 1 day deadline, start ACAS early conciliation and run the 2 processes in parallel. And sometimes, or the appeal. Sometimes even ACAS will be like, "Oh, you didn't finish the grievance," and I'm like, "You only have 3 months. Like, how in the world are you supposed to control the time limit of when your employer actually engages with the process?" So don't take their shit with this. Honestly, file. If you're going to hit that deadline, like, don't do it like a month before. Like, if you're going to hit that deadline, though, start ACAS early conciliation. That is so much the safer bet to take than to try, because you can guarantee that if you wait until after the grievance is done and then you file an ET1, the first thing the employer is going to say when they come back is, "Oh, they're out of time. They missed the deadline," even though they had control over the delay as well. So do not let them gaslight you into waiting. Hopefully that has, you can see how, it really pisses me off. Okay, so I've got about 10 minutes. So let's see how many more we can get through here. Okay, someone, so TC is saying, "I didn't want to raise an appeal because I didn't want to go back to the toxic work environment." TC, it's understandable. The judge, say you won your case and they asked for the award to be reduced because you didn't raise an appeal, the judge will ask you about this. And you just need to have an answer to say, the environment was so terrible, it was bad for my health, or, whatever is true, basically. And then the judge will take that into consideration. Okay, let's see. I've started my ET1. I was unfairly dismissed after 3.5 years. The employer is claiming that as I was self-employed, I have no case. Let's see. I'm assuming that you believe that you were not self-employed and that you actually had worker status. Is that correct, EQ? And whilst you're typing, I will go look over here. So, my employer made a without prejudice offer before I had received my appeal result. Shelby, that is totally normal. And for a lot of people, a without prejudice offer, which is a settlement offer, that is a very normal thing to receive out of the blue anytime you raise an issue with your employer, because they'll be doing the maths and they'll be like, "Oh, this is going to cost this much in legal costs, this much in time," and then they'll give what they think is like a reasonable lowball offer. Whether or not that offer makes sense to you is completely up to you. And this is why we built that merits assessment product that's on the homepage, top thing on the homepage. That is, we designed that to be affordable at £149 and to have that conversation with someone so that you can go to someone and get clarity and say, "Is this worth this offer or is this something else?" And then even if that's it, you just take the offer, you will have just had that little bit more peace of mind and feel like you have that little bit more control in the situation. Because that's what I'm seeing so much from people, is just like, I didn't feel like I had any other way to find out or know because I couldn't afford anything else. And so I just had to take it. And then you're just kind of left wondering, was that good? Was that bad? I don't know. How am I meant to know? So that's why we've designed that product. Someone said, "I have a merits assessment coming up today, Andrew." Oh, well, that's wonderful. That's wonderful. I'm glad to hear that. If we also, on a merits assessment, if we don't think that there is actually a case that could succeed in tribunal, we will tell you that. We will absolutely tell you that, and we will tell you why. And, sometimes that can be difficult to hear, but I often think from what I'm talking to our users about it, at least and at least you got someone with the right legal credentials to look at it and to tell you. And at least, hopefully, if nothing else, you can then move on to hopefully better things. And so yeah, I hopefully that is super valuable. Are we UK based? Yes, we are, Sam. I know that's probably because I have a weird accent. I'm originally from Tennessee and live in Edinburgh. And Vala is a UK company. We are registered in Scotland. We have clients all across England, Scotland, and Wales. So yeah. And actually now we're kind of embedded into the UK legal system. So for example, I sit on the national user group for the Employment Tribunal, which basically means that I just sit with all the judges and the president of the tribunal and ACAS and Citizens Advice and people like that. And behind the scenes looking at how many cases are coming through, what the problems are, how we can help, that kind of stuff. Okay, just a few more. Do employers really worry about tribunal cases against them? It's disability discrimination in Philippa's case. I mean, it really depends on the employer. Like there's so many different kinds of employers. Some of them will worry about reputational damage. Almost all of them will worry about the legal costs. It's not cheap to get support from a lawyer. And so that's probably one of the things that they are most concerned about. Especially if you think about the sheer amount of time, a barrister could cost anywhere from £200 to £1,000 an hour, and a 3-day hearing or a 5-day hearing, that's a lot of money. So that's typically the first thing that we kind of know. Someone says, if I book a merits assessment, is that with me or with one of my team? That is with one of my team, Football. So we work with, so I've learned a lot about employment tribunal, employment law and employment tribunals, but I am not a lawyer. But our legal coaches, they are. So they are either SRA registered lawyers or sometimes solicitors. Sometimes they're solicitors, but they're just not on the practicing books anymore. Sometimes they're SILEX accredited, which is another type of accreditation. Sometimes they are people who have come from like an HR or a charity background, but they have tons of litigation experience. Like they're super savvy. So we always screen mainly for the tribunal experience, and then the accreditations are kind of like a cherry on top. What is the maximum amount you can ask for when making an offer? Really depends on the situation, Ellie. Massively depends on the type of claim. And this is the one thing that I want everyone to understand, is that all the leverage that you have when you're making a settlement negotiation is about what this could win at tribunal. That is a huge part of it. And what it could win at tribunal is based on what the claims are and what the circumstances of the cases are. And so if you know your claims, you have the most power in this situation. And that's why we're so obsessed with the claims on the platform, which is a free part. If you go into vala.uk and you create a free account, there's like a claims section where you can kind of understand this yourself for free. And that's why we built that merits assessment, because the output of that report is this claim, no, this claim, yeah, this claim, yeah. Like that's why we tell you that, because then you will be able to gauge what to ask for and how much it could win in tribunal. That is the most powerful thing that you can do, is just absolutely obsess about the potential claims. Okay, right. So Ellie, have I frozen? Have I frozen for anyone else? The key thing I was just talking about there, Ellie, is that it's all about the claims. Absolutely all about the claims. And which is why we focus so much on that merits assessment tool, because that gives, thank you, and because that gives you the understanding of what the claims are, so that you then have the power to understand what you could win in the tribunal. Great question from Andrew. Would you be able to add the functionality on the website to be able to edit document names and categories? I will pass that on to the team, Andrew. Thank you very much. I will let them know. Oh, SDP, your legal coach, Anna, is amazing. She's really helping me. Oh, that's wonderful. That's wonderful. Anna's fantastic. So detail-oriented, Anna, which I love about her. Not that they all aren't, but Anna in particular, like I love that she explains a lot, which I think is super helpful. Olivia, I signed the NDA as part of the settlement. Will I be able to speak out if the new bill goes through? Only if it's retroactive, and I would be surprised if it was. So I suspect not, Olivia, but we'll see. I've been going through a grievance at work since March, and it's finally getting some time with ACAS. I hope we can reach a settlement, as it's seriously draining. I completely agree. I completely understand. And that's one of the other reasons why we do these lives and the employment tribunal support group is because this is a difficult process, and you really, and I think it's designed to make you feel isolated. And so we try to combat that with things like this, because we don't want you to be isolated, because you're not. You're all going through these kinds of problems. Can the equality team at work solve a reasonable adjustment situation because of a disability? They certainly should be trying to. And it's only if they can't resolve it or refuse to try and resolve it that you would raise a failure to make reasonable adjustments claim. And but that is certainly a potential claim that you could raise if they're not engaging, or if they're not really giving you the reasonable adjustments that you believe you need. Thanks to you, I proceeded to tribunal. The organization folded after 2 hearings. The settlement agreement was key and allowed me to move on. Oh, can we all just give David some love hearts? Well done, David. Congratulations. That's fantastic. Like, super well done. Really well done. Oh, this is brilliant. Okay. My union rep was was intimidated, which made my hearings unpleasant. Yeah, I think unions, I think there's a massive ask for unions these days, because employment laws become a lot more complex. And yeah, that is, like, it's tough. Like, it's tough to stay on top of everything and do your regular job. And we're actually starting to work with unions now, and are working with already quite a few. And so we're supporting them to support their members and their reps. So if any of you are part of a union and you want VALA support, go ask your union rep about it and tell them to get in touch with us. There's a website, there's a link on the website, VALA for Unions. What is the free case builder you have just discussed? If you go into the VALA platform, Sam, vala.uk, you create a free account, and then you go to claims. You will see the free claim label, like it's like a wizard to help you try and understand it. That's where I would start to try and understand your claim. And then from there, if you want a second opinion, if you need more support, I would then use the merits assessment product. My employer wanted to give me a settlement of £5,000 during early conciliation. Interestingly, they refused to compensate me during the grievance process. That doesn't make sense. I don't know what you mean by compensate me through the grievance process. Is there guidance on how quickly employers should deal with grievances? Unfortunately, ACAS did not give like a formal timeline, but they do say it should be quickly, or no, reasonable. And so I would say generally, more than anything, you really need to make sure that you don't miss that ACAS early conciliation deadline of 3 months minus 1 day after the bad thing happened. But I would say anytime over a month is starting to move into unreasonable territory. And I've heard about people who've been waiting for like 2 or 3 years for a grievance outcome, which is absolutely like not okay. All right. My case has been pushed back due to a solicitor change. Is there a cap on compensation? It's been 3 years. I don't know is the short version, Ellie. I'm so sorry. I don't think I have enough context to answer that question here, but I will answer your question with the next question, because I'm going to need to go after this. How do I get into contact with you? So first of all, you don't want to talk to me. I'm here to, well, you can talk to me here. I love talking to you all here. But if you want to talk to one of our coaches, they're going to be the ones who are going to talk you through this. They're going to be the ones that will look at the specifics of your situation. And you can do that by going to vala.uk and create a free account. And then you can look in coaching, and you can look in the template section to see what suits you the best. You can also email us. We have a very lovely team on email. They are at hello@vala.uk. That's just hello@valla.uk. And they are so nice. And if you're not sure where to start with us or what we can do to help, I would highly recommend just emailing us, hello@vala, and asking, you know, how could you help me? And the team are so lovely, and they will tell you what we think we can do to give you some help. All right. Oh, David, well done. David's first settlement offer was £4,500, and in the end, they settled for more than 40,000. David, that's amazing. Have we worked with, like, David, have we asked you if you'd be willing to be a case study? If we haven't, and you are willing, please do drop us an email and hello, because I would love to Like, I'm just so delighted for you. That's wonderful. And you, David, you can't see it, but over on TikTok, lots of people are saying well done there as well. All right, I'm so sorry that I have to go. I have to go do a. David says, please contact me. If you drop me just drop us a message on YouTube, David. Just something where we can something private where we can get your email address. We will contact you. That would be amazing. Right, I have a meeting, so I have to go. Thank you all so much for coming today, and it's such a pleasure to see you all. And thank you for all of your questions. If I have not been able to answer your question, do not fear. We have a whole team that can help you, and they are at hello@vala.uk. And so if there are any other questions that you just want to run by us, drop us an email there, and the very lovely team will say hello to you. Right, have a great day, everyone. I am thinking about you. You are not alone. You are doing such a good job, and we will talk to you soon. Bye-bye. See you later. See you later, all.